Donald Trump is a big fan of them and advises everybody to get one, at least once. He allegedly called Paul McCartney a schmuck for not obtaining one. What am I talking about? A prenuptial agreement. A prenuptial is a contract made between two people who propose to marry one another in respect to property, maintenance and custody arrangements should the marriage break down. My next guest, family law expert Gerry Shannon, maintains the prenuptial contracts are of increasing practical importance in this jurisdiction since the passing of the Divorce Act over a decade ago. His new book, looking at divorce now 10 years on, called Divorce, Law and Practice, has just been published, and he joins us in studio this morning. Gerry, good morning and welcome.
Good morning, Gerry.
I see that a number of commentators are saying that today is D-Day, or maybe it was last Monday, that everybody will be rushing off to the solicitor's office to put in place proceedings for divorce and separation as a result of the increasing levels of pressure that they experienced at home over the Yuletide break. Is that true, do you think?
Yeah, I don't think it's true, but I think it's
good.
It's a pressure point. I suppose the introduction is quite interesting, particularly in the context of Donald Trump, because if you look at Donald Trump got burned really in the context of his own marital situation, because his wife, I think she was heard saying that you don't get mad, you get everything. And in fact, when she, I think it was 1992,
and she led the clarion cry for women to completely change their levels of aggression in terms of divorce.
It's quite a serious point there, because she's written a very interesting book on actually her experience. She took him for $10 million dollars in 1992, which was a lot of spondulics at that time.
You're being in sock now.
Of course. But in addition, she got, I think, $4 million for leaving the apartment, $350,000 per year. She did very well, but she did it in a very sensible way. And I think that's the message. She was quite calm and quite collected. And there are a lot of those, actually, particularly in terms of the big money cases coming through in the UK, because if you look at what's happened there, it started off in about 2000, where women were getting about 20% of the assets. And it started with a guy called Michael Cowan. Now, many of your listeners may have heard of Cowan, because Cowan is more readily associated with bin liners. He made a fortune out of bin liners. And when he separated, he agreed to give his wife about 20% of the assets. And his wife, Jackie, said, well, that's not good enough. I want more than that. And that started the ball rolling in the UK. And she got about a third of the assets.
Based on what, Gerry?
Based on what? Well, there are two, I suppose, approaches. In Ireland, it's unclear as to how the assets are divvied up.
Actually, we'll come to that in a minute, because we have a different system to the UK. But in the UK, because you're now suggesting that maybe some of the case law and some of the precedents that have been set by judgments in the UK may be useful for us in deciding the future of divorce and the divvy up in particular in this jurisdiction. How in that case, how in the Cowan case, did they decide that she was entitled to 30%?
Because of the fact that they look at marriage in a different way to the way we look at marriage. In England, marriage is viewed as an equal partnership with both parties sharing the financial fruits of the marriage partnership. So it's a 50-50 split unless there are exceptional circumstances. In other words, if one party brings a lot of property into the marriage, well, then there can be a departure from that. Now, that's been a big change over the last number of years, because it started off with England being much less generous to the dependent spouse than Ireland. And that's changed radically. And I'll give you a few examples of cases where that's occurred, because I think many people will have heard these in the media and they mightn't just realise the significance of them. The first one, as I said, was Michael Cowan, and she got a third. That was a big deal at that time in 2000 because of the fact that it was a big departure moving from about...
What was her argument or her case?
She argued very clearly that she was central to him building up that fortune. The fact that she looked after the kids, she looked after his affairs, gave him the capacity and the resources to build up his fortune.
And that could be true.
And it is true, one could argue, because of the fact I think we fare behind the UK at the moment. And we come to that later in the context of what we give to the homemaker or child carer. But the next case was a guy called Harry Lambert. Now, Harry Lambert, again, he had a publishing company, and he famously said when he separated, he was asked, well, what's the contribution of your wife to all of this? Well, he said her contribution revolved around the microwave and the children. Now, that cost him dearly in the context of, he ended up giving 50% of his assets.
Now, when you
to
say
his wife.
cost him dearly, and the reason we're focusing on the UK at the moment is that these considerations may become part of Irish thinking in the future. He makes that statement before the case is finished, right? Now, do you believe that affected the bench when the judge was making it? Because it's not a jury, by the way, thank God, that's making the decisions on these occasions, because God only knows how the case law would look. But how did the judge... How do you think the judge was affected by that statement?
I don't think the judge was affected, but I suppose his entire approach was the traditional approach in the UK. So we'll give you enough to get by on a day-to-day type of basis, and we'll give you little more than that. But we see this was a big departure because of the fact she was now getting 50% of the assets. So it wasn't what he said, but the general attitude was that you looked after the kids, you did the cooking, and we'll give you 20% of the assets for that. Yeah. Then you had the famous Marks case, Stephen Marks, you may know the Marks chain, retail chain. He ended up having to sell 40 million of his shares in the retail chain to fund a divorce settlement of £50 million to his wife, Alicia. And the marriage there was only 10 years. So that's very significant. And we come to McCartney later in the context, but it's all building up to where things are going in the UK. Perhaps the biggest payout was in a case which settled. So we're only going on really hearsay, but it dealt with a guy called Peter Harrison. Peter Harrison built up a massive wealth. His wealth, it was estimated, ran to about 200 million. Now, reports and credible reports would appear to indicate that he settled for 100 million to his wife, which a big payout. Many of you will have heard of Arsenal footballer Ray Parlour. Now, Karen Parlour was no pushover, because what Karen Parlour said is that she was responsible for his success. She said that she succeeded in keeping him from a life other than one which he now enjoyed. In other words, she kept him on the straight and narrow, and she said she was entitled to a significant payout as a result of that. She got £2 million sterling, she got a large lump sum, and she got, for the first time in the UK, she got 37.5%, I think, of his assets for a period of 4 years. Now, in the UK, up to that point, what you got what was called a clean break. In other words, up to that you were getting, this is what you get, and you move on with your life and you get no more. And that was built on then. Karen Parlour started the ball rolling. About 2 years ago, two cases which were very much in the public domain was a case involving a woman called Melissa Miller. You may have heard it. Two cases, Miller and McFarlane. Melissa Miller had a rather short marriage. It lasted 2 years and 9 months. Now, as a result of that marriage, she got, I think it was £5 million sterling from the Court of Appeal. Now, everybody said, well, there's no way that's going to be upheld by the House of Lords. But when it came to the House of Lords upheld it. Now, that was, I suppose, a jaw-dropping amount. At the time, it was described as a meal ticket for life, and had significant implications, because it meant that even in the context of a short marriage, that you could end up getting 50% of the income generated during that marriage. And that sent shockwaves down the spines of males, not only in the UK but also in Ireland, contemplating divorce. Because if you had a short marriage, the conventional wisdom was that the payout wouldn't be that great. And on the same day, the House of Lords handed down another decision, the McFarlane decision. Julie McFarlane had given up a career as a solicitor, and she had looked after the kids. The marriage lasted a period of, I think it was 16 years. Now, the Court of Appeal just to give your listeners an idea as to how things work, the Court of Appeal is the second, I suppose, biggest court. Next to that is the House of Lords. They'd said to her, well, we'll give you £250,000 a year for 5 years. The House of Lords said, no, we're going to give you £250,000 a year indefinitely into the future, and we're going to give you 50% of everything he has. Now, that really set the cat among the pigeons.
And what was the thinking there? Because this is the ghost in the machine. It's very hard to define the things that we've just been talking about, and it's inevitably a woman at this stage in our anthropological history. It's inevitably a woman. What has she given? Stability. She has raised the children. She has freed you up from domestic obligation. She's given you maybe public credibility. She has become part possibly of your story to your industry, right? So how do you quantify that? Is that worth 50% of the money that the male usually, it's usually the male, though not inevitably, and there's it could be a woman. How do you say that that's worth 250,000 a year indefinitely and 50% of all the assets? Is it because it would be immoral, incorrect, inappropriate, inequitable to downgrade her from that position just because the marriage has failed?
Yeah, there are a number of reasons. The first one is the fact that she's given up. Many women have given up very successful careers and have lost advancement opportunities as a result of looking after the kids.
Advanced in life as well, where they can't restart.
They can't restart, and that's a significant factor. So I think the English approach is a sensible approach, is that you look at it as an equal partnership. And if marriage is an equal partnership, well, then it's a 50-50 split of the assets, unless there are exceptional circumstances. And exceptional circumstances will be where one party bought a lot of property to the marriage, one party inherited property. But that is the starting point. So the UK is actually very clear on that. We're not as clear, because if you look even last year...
Well, let's have a look at what the Irish law is, because we do not have clean break divorce in this country. We go back to the Constitution, which cherishes the family and at least a married couple and their family as the ultimate in terms of relationship and in terms of deserving of support of the courts, of society, of the Constitution, of everything, basically. So marriage is the gold standard, as you say in the book. Now, that means that when we come to dissolve it in this country, we have a completely different attitude.
Yeah, we have. And if we look at what's happened, and even during the last 10 years, since people voted for divorce, things have changed radically. Because what we've seen is rapid change, considerable economic wealth leading to increased personal wealth. We have 33,000 millionaires in Ireland at the moment. It's a much different Ireland than the Ireland that voted for divorce over a decade ago. And what's happened in the meantime is, in fact, we've had a relatively low uptake in relation to divorce up until about 2 or 3 years ago. Because if you look at the data, it's much lower than other countries experienced. And there are a number of reasons for that. The first one is people didn't know what to expect. People didn't know how the system worked. The apprehension of people towards this new system. And if you are in an arrangement, in other words, if you had separated and you had no new partner in the offing, well, then you weren't going to be looking for this new particular remedy. But the system has settled down now. What we're seeing over the last number of years is a relative increase. You could also describe it as a significant increase. And I suppose if we look at the myths, at the time of the divorce referendum, we were told that women were going to be impoverished. But female applicants outnumber male applicants by 2 to 1. And no great surprise there, because in the UK, 93% of wives petition for divorce. Some of the data not available to us, and I think it's data we should have available to us, is why do people divorce? We need to look at that. In the UK, it would appear that adultery is the major cause for people divorcing. But close behind that is actually family strain. Family strain has shown a significant increase in the UK, up from 11 to 18%. Now, in my opinion, that's a big jump. But
what is family strain?
Family strain is the fact that the two parents working, trying to do everything, and as a result of that, their relationship suffering. So I think the lesson for that is we need to support marriage and support families. And I think that has to be the starting point. Progress has been made in providing support services. So where cracks are beginning to appear in the marriage, that we provide support. What we do is, in my opinion, on many occasions, we do it when it's too late. I think we've got to be far more robust in support services we provide to parents. And I think that's, I suppose, one way forward. But in terms of the divvy out here, how it works is on the basis of what's called proper provision. So the courts are told, go forth and ensure proper provision. And you're provided with a number of factors. And there are so many factors the court can take into account that it's very difficult to discern any type of trend. Because despite 10 years of practice, it would appear that most cases are decided on the unique and specific facts that exist in an individual case. The courts are given a lot of discretion, and so it's up to each individual judge to exercise that discretion. Now, what I say in the book and what I argue is that we need clear principles as to how the assets are divided on the breakup of a marriage. In the UK, how it's dealt with is quite clear.
Well, you can say to a client, though, these are the things that can be considered when we go into court, and these other things cannot be considered. For instance, what you can't bring to court is the fact that you hate your husband, or that you hate your wife, or that she got into bed with your brother-in-law, or whatever. None of that stuff's relevant. That's all irrelevant.
Yeah.
Now, obviously, if there's emotional or physical violence involved, and of course the definition of emotional violence is very, very difficult, but certainly if there was physical violence or a physical threat to the family, that you could consider that. But otherwise, there is no blame divorce.
And it's no fault divorce. You're absolutely
It's a
right.
no fault divorce.
And if we look at it, the first major
And
case,
that's frequently the reason people want to get divorced in this country is you bastard, you bitch. And then they realise when they get into the solicitor's office, oh, they're not going to accommodate my fury here. This is not very good.
Yeah, and it's a really important point, because you're right. It's a no-fault divorce-based system.
It's business.
It's business, exactly. The court are in the business of reordering the assets of the parties in the breakdown of the marriage. The court, in reordering the assets, is not concerned with matrimonial behaviour and will consider conduct only if it would be what the court describes as repugnant to justice to ignore it. And what do we mean by that? We mean conduct that's gross and obvious. In other words, short of domestic violence, the court isn't interested in taking into account conduct. And the first major divorce case to come before the Supreme Court dealt with this issue. It would appear that there was a relationship during the marriage, shortly after the marriage broke down. We see a child resulted from that relationship. Now, that the High Court judge decided that this was conduct. The Supreme Court said, no, it's not conduct.
It's not.
Because the fact
it's not very nice.
It's not very nice, and you're absolutely right. And that's what I think people have to realise, is that when you divorce, it's not about retribution. It's about helping the parties to move on, dividing the assets in an equitable fashion. And that's the way the UK courts approach it. And they set down 3 principles. The first one is need. What do the parties need? The second is compensation. What we talked about there in the context of whether it's McFarlane or whether it's Miller, it's about compensating a spouse for loss of opportunity, and it's then the sharing of the assets. So it's divvying out the assets in an equitable fashion. So those are 3 principles. At the moment in Ireland, if a judge is asked to decide on this, the judge is meant to be divinely inspired, proper provision. And what the Supreme Court have said is, what will you get in Ireland? Well, you'll get somewhere between a third and a half of the assets. Now, 2 of the Supreme Court judges in the major decision on divorce have said that the benchmark is a third of the net assets. The other judges weren't so sure about that.
Does that include maintenance for children?
It would, yeah. It would generally include...
So the whole package is generally around a third.
Between a third and a half. With 2 of the judges of this in the major
and by the way,
in
perpetuity, effectively, because in this jurisdiction you can keep coming back, man or woman or beast, back to the court and saying, she's after winning the lotto. Yeah. She's much richer than me now. I want some money out of that.
And that's an important point, because you're not even safe in death. You can be pursued beyond the grave.
Oh no, your estate can be got as well.
Exactly, and people laugh when you say that, but it's true, because a secured maintenance order will ensure that the liability continues after death.
We're talking about the differences between divorce in this jurisdiction and in the UK, because inevitably we will look towards the UK. At least I think we will, Jeffrey, for our lead in the future. And change will come in time, because that's the way law is an organic thing. It has to evolve to represent contemporary society. The question I asked before the break, in whose interests generally is it to look for a divorce, a man or a woman's?
Yeah, it's a very difficult question, because it's down to the Irish system. Is pretty much, it depends on the judge you get on the day as to how the judge is going to.
Can it vary that much?
It can vary that much.
And because we have in-camera reporting, we've no precedent, have we?
We haven't, and we have, I suppose, Carol Coulter spearheaded, I think, a very useful and a very productive initiative. She looked behind what was going on in the circuit court, and those were reported by the court service. I think that was a very useful initiative. But given the fact that the courts are given so much discretion, it's how that discretion is exercised will determine what you get at the end of the day. Now, if you're in the UK, if you are a dependent spouse, in other words, you're the stay-at-home mother, you're likely to get 50% of the net assets. In Ireland, you're more likely to get a third. So if you can issue proceedings in the UK and you're a dependent spouse, of course, the UK, London's much more attractive than Dublin. And that's what we need to look at, because a regulation came in 2001, March 2001, allowing somebody who's what's called habitually resident. Now, what habitually resident is, Gerry, is if you live in a jurisdiction for a period of time, generally for a period of a year, you can issue there. Now, if you're actually a wealthy husband, well, you won't want your wife to issue in London in case she gets 50% of the assets. So there's been a lot of divorce planning and forum shopping in the context of wealthy couples, because you're going to look to where you're going to get the best possible deal. In Ireland, there's so much discretion that it's very difficult to predict how things are going to operate.
Well, they look, initially, if there's children, that's the first place to look, isn't it?
Yeah, of course. If there are children involved, the court
and
has
surely,
to be
surely there's some level of precedent in the way the children have to be taken care of.
Yeah, and with children, we don't even consider children, in my opinion, in the context of divorce. We've been very poor on this issue. Divorce comes as a huge shock for children and provokes an emotional crisis akin to a bereavement. And we seem to treat children, in my opinion, a bit like any other chattel. If you stand outside any courtroom, you'll sometimes hear the lawyers talking about, well, who got the family home and who got the children. But what we fail to realise is that when parents separate, it's not just the husband and wife who suffer the emotional effects. The emotional maelstrom that is divorce impacts on the entire household. Children are deeply affected as family routines fall apart and parenting skills are diminished by the looming divorce. And children, in my opinion, adopt a sort of a shadowy presence and assume a marginal position following a divorce. And it's sort of ironic because our law says...
They're not consulted either.
They're not consulted.
Because we believe it's not in their interest to have them in court.
Yeah, and I have actually just taken with me... kids were interviewed in the context of divorce, and can I just read to you what three of the kids had to say?
Okay, let's hear it. Do you need your glasses, do you?
No. And it's really powerful. For me, it brought home just the impact that divorce has actually on kids.
These are Irish children.
These are kids. I was part of a research project a number of years ago that looked at the impact of divorce on children. And the first one was a kid aged 13, and she said, it was like, oh, well, it's not really your problem. You're not going to be affected by it. You don't have to go through all the divorce thing. But no one seemed to realise I was sort of there. They were all concerned with what they were doing. That's the first.
In other words, I've been ignored.
I've been ignored, exactly. Susan, aged 14, she said, I wanted to know why she did it. I wanted some answers, and Mum didn't give me any answers. It would have been better if she told me, then maybe we'd have a closer relationship now. Because if we knew the truth, then we could have just cleared the air. But that didn't happen. It's still going on now. You never talk about it, but it's still there. Louise, aged 12, this is what she had to say. Mum, she didn't really talk to me much. She was always upset, and I couldn't really say to her, I'm upset too. I need a really good chat with you. So that for me brought home the reality of divorce for kids, is that they're very central to the entire process, and by pretending it's not happening, we're ignoring the needs of these kids. And one Supreme Court judge described kids in divorce as kids of Armageddon, and that's a really powerful image. And I think it just indicates that we've got to ensure that we take into account the perspective of the child when parents are divorcing, that we've got to meet their support needs.
How would you do that, though? For instance, the only sort of human dimension that a legal practitioner is obliged to inject into the proceedings is when you sit down in front of him or her and you say, well, I have a problem with my marriage, I'm thinking of having a separation or filing for divorce, and they'll say, well, I'm obliged to suggest marital guidance, counselling or mediation. Have you considered that? And then you go, no, I don't want that, couldn't be bothered, it's irreconcilable. Okay, right, move on. Yeah. That's about it. Yeah. That's the extent of humanity in the Irish practice.
Mm-hmm. And you're right.
So how are we going to move on from there?
How we move on from there is, I think parents need to realise that divorce has a huge impact on kids, and that when they actually come to settle, so they don't adopt polar positions, because there is life after divorce. And it's not about consulting children. It's more than that. It's about realising that the kids will still have two parents following a divorce, and that they should attempt to reorganise their affairs in a manner that will ensure that the kids have access to two parents following the divorce. I think that that's important. And also to tell the kids what's happening. Of course, you're not going to say it to a 6 or 7 year old, but to teenage kids to say, well, this is what's happening and this is how we're dealing with it. Because
it's a huge challenge, though, for ordinary people, because international best practice tells us the best way to separate with the view to a divorce or to go straight to is to continue to appear as a team to your children, to keep the rowing and shouting down to a bare minimum, to keep the main detail of the unseemly nature or otherwise of whatever's happened in your relationship away from your children, to tell them that something has happened that's big and that separates mum and dad, but that mum and dad are together in relation to the children. Now, that's your utopia, right? Most people are not able to deliver that.
Yeah, and that's why I think we need to
the only way we could do it is basically by telling people if you don't do that, you're going to jail. Right.
Yeah. And that's not the way to deal with it.
No.
And I don't have the answers to all of these questions. But what I will say is that you started off by saying what is solicitors obliged to do when the client arrives into the office is to advise on mediation. In my opinion, that's just not enough in the context of ensuring that kids are protected. We need a far more robust mechanism. And what happens, and just to give you an idea as to how other countries
but
actually
people
deal
who
with
do
it,
actually take up that offer of mediation frequently arrive at a solution, or not frequently, I'm a bit optimistic there myself. But there are some who do arrive at a much more human solution for each other and for the children.
And the outcome, it's not just mediation. I'm a strong advocate of mediation, but I think 10 years on, we need to look at how the system is operating. And one of the areas I would target is mediation. And also there's a new process called collaborative law, where the lawyers sit down and you deal with it as a problem rather than as two separate sets of lawyers. And that has far more beneficial outcomes insofar as
the Americans
children
are
concerned.
quite advanced in that
on
area.
that, yeah, and they do. And I think we're now beginning to look at that, and that offers a lot of hope in the context of resolving cases amicably. Because you're right, if the two sets of parents are in obdurate conflict, that's going to have a huge impact on the kids. So we should put the kids first, the interests of the kids first.
And on them. That's when you get down to, the George Best card set, that's mine.
Yeah.
That's when you get down to that. And that just destroys everybody.
It does.
And lines lawyers' pockets.
Yeah, and exactly. That's what my view, and I argue strongly in the book, is that what we need to do is, for all parties, it's not just a question of promoting, but we need more widespread use, not only of mediation, but also of collaborative law.
Look at those two areas that you've mentioned. Collaborative law, which is not the two parties going to the one solicitor, by the way. It's the parties going to two solicitors who agree to work in an objective way, not subjectively, to solve the problem of the divorce. Not to get them back together again, but to solve the problem of the divorce in a way that's equitable, fair to everybody. And the other, mediation is...
And there's just one caveat to that, Gerry, is that if the lawyers aren't successful in resolving the case, they cannot take the case to court. They must hand it on to another lawyer. So there is actually a real incentive from the lawyer's perspective in actually solving the problem, because that's what it's looked at.
What do you get at the end of that? You get a divorce, obviously.
You get a divorce. The outcome is
without
still the
contesting.
Same. Exactly. And without the conflict and without the hostility, because when parents divorce, they adopt polar positions, and it's very difficult
then.
Which
is understandable and human, because people are
totally
hurt.
Human. Yeah. So I think the system needs to look at this as how can we ensure better outcomes insofar as kids are concerned? Because
how do you describe that when you're, when you go to a lawyer? And I mean, there's a huge number of practices now who will have very sophisticated matrimonial and marital law practices or departments with very experienced people. Now, they may be experienced in ways that are more combative than would be advisable for somebody who's looking for this collaborative law experience, but nonetheless, the expertise is there. What do you say when you go into a lawyer's office looking for that?
Yeah, because I think there is an obligation to legislate around this, because it shouldn't just be an option. Because in 1997, when we looked at this issue, once divorce kicked in, we hadn't really considered the impact of divorce on children. What we'd done is we'd looked at the financial aspects without looking at the impact that divorce was having on kids. And what we're now seeing is divorce has this impact, so that you would actually introduce legislation creating sort of an incentive. And you're right when you said about it. You can't beat people into adopting a non-adversarial approach. You've got to provide incentives. What they do in the US is pretty much you're showing a video of, this is what will happen if you actually divorce in an acrimonious manner. And this is what will happen. These are the benefits of actually divorcing in a
mutually agreeable way.
And I think that's important, because if the parties mutually agree on the terms, in terms of custody and access, and also in terms of the financial terms, that's going to be far more enduring than a system that's foisted upon them by a party who barely knows the parents and the children involved. So I think that we've got to look at that, and it's now happening right across Europe. Particularly the UK are actually very good on this, because
is there much instance of it here in this country? If you go into an office and you say, look, my marriage is breaking down, I feel that it's heading towards divorce, I would really like to try and make it as fair and as reasonable for everybody. And usually what you're actually saying when you say that is for me and for everybody. I'd like it to be a collaborative legal job. can the lawyer then say, OK, I'm taking it on that basis, I will await your husband's instructions from his solicitor, and then I will suggest to his solicitor it should be done collaboratively? How does it work?
Yeah, and there has been some training in this jurisdiction on that issue. There's a Collaborative Lawyers Association. So there's been, because it's not just you don't become a collaborative lawyer overnight. You've got to be trained on this particular skill.
It's a totally different skill.
Exactly. And that's been occurring over the last number of years. So it'll take some time, but I think it also needs the support of government, and it needs the support of legislation, and that's how you move forward. Change is incremental. So let's start doing it now.
There? Are they there yet?
They are there, yeah. There are a number of collaborative lawyers within the jurisdiction.
Do they wear corduroy and no ties?
Yeah.
Are they the same as the rest of you?
That's the same as the rest of the lawyers. But mediation then is also, because collaborative law may not suit some people, it may suit other people. So what we need a number of options.
Now, can you describe what mediation is?
Mediation it's a process whereby the parties decide on the issues that need to be resolved and agree on those issues. Now, we have a very good family mediation service, which certainly was established once our divorce system was up and running. What we need an expansion of that service. So
what teeth has it got? If you go to the mediation service, and these are people who are trained to mediate, they're totally objective. They're not interested in the tears. They're not interested in the she's an absolute cow stuff. They will sit and allow you vent all that if you want to, and then they'll eventually always return to business. They will always return to business and coming up with an equitable arrangement in terms of the issues. Try and identify what those issues are and see if the common ground can be found with a solution for them. What teeth do they have to enforce that agreement?
Yeah, mediation has a very weak legislative footing, and that's why I think in terms of moving forward we need to look at that. You'll agree the terms, and then that agreement can be made as something akin to a legally binding type of agreement. But there are a couple of difficulties with it. The first is in the context of a divorce. You can only split a pension by means of having a court order. So you've got to go to court in the first instance. Even if you don't want, I suppose, to go to court. And I think we've got to change that. And parties shouldn't be forced to go to court unless it's absolutely necessary. And all that requires is a legislative change. Also in the context of a regulation introduced in 2001, which gives priority to the person who issues first. Well, again, that militates against mediation because of the fact that it forces the parties to issue proceedings before they have the opportunity to engage in mediation.
To the proceedings.
Exactly, yes. And if you don't get in first, your counterpart will get a jurisdictional advantage. And we talked about that. In the UK, if you are actually a wealthy spouse, you're going to be rushing to issue in Dublin rather than in London, because the fact, if your counterpart issues in London, she's going to do much better. So in my opinion, we've got to look at those issues so that mediation is supported at all levels. We've got to take
the tripwires out of it.
Exactly, yeah.
Okay, and we're talking divorce. We're talking what leads to divorce. Separation, of course, which is an entirely different thing. It's basically a contract agreeing not to be with one another anymore and putting in place certain mechanical and business and custody arrangements and access arrangements in a contract. People don't really understand that. People often think that it's a sort of mini divorce. It's not a mini divorce.
Yeah, and let's just explain it. Separation. Separation is where two people decide that they want to live separate and apart, and they put together a contract, and that contract relieves them from the duty to cohabit and decides who's going to get what. Now, again, it's a legally binding contract, but you can't deal with pensions.
But it's no different than the contract you have with NTL for your telly. It's a contract.
Yeah, it's a contract, exactly. Yeah. But one thing is, if you get your separation agreement, you can't then get what's called a judicial separation. So let's say you have a pension. The only way that your pension can be split is by means of getting a court order. So the option there will not be a separation agreement, it will be a judicial separation. And then the other option is divorce. So you can get a separation agreement and then subsequently get a divorce. But that's an interesting issue, Gerry, because what's happened is a lot of the cases that have come before the courts have dealt with cases where the parties have prior existing separation agreements. Let's take an example. Husband separates from wife. Husband makes a fortune from the time of separation up until the time of the divorce. The first divorce case in this country dealt with that. 80% of the assets were accumulated after the separation. So how does the court deal with that? Well, there are three factors the court will take into account. The first is the length of time since the separation agreement, the reasonable expectation of the parties. Those will be, I suppose, the two core aspects. And in addition to that, what the court will do is will look at all of the other surrounding circumstances. So let's say if your separation agreement was signed in the 80s and you were coming back for a divorce now, well, you can expect that you're going to get a significant increase in the assets. Now, there was a case where
And you can keep coming back again and again after that divorce.
Indefinitely, yeah.
To the tomb.
Exactly.
And beyond.
To the tomb, yeah, because three factors: length of time, the financial background against which the agreement was reached, the reasonable expectations of the parties. That's what the court will look at in the context of a divorce. So I come back 10 years later and I'm looking for an extra bite of the cherry. Well, the court is going to look at all of those factors. But let there be no doubt, there is no clean break in Ireland. So there's nothing preventing you from going back 2 months later looking for an extra bite of the cherry.
And there are people who become serial appellants, I suppose, in a way, who continually go back to have the divorce settlement redefined by the court. There are people who do that.
Exactly, and you've got three opportunities.
So divorce becomes your life.
It can become your life, and it hasn't in certain cases, because if we look at, you get your separation agreements, that's your first bite of the cherry. Then your next bite of the cherry is the context of divorce. Now, there is a third bite of the cherry, because after divorce, in a recent case, the court has granted further provision to a party, even though a divorce has been granted. Now, that wouldn't happen in any other country in the world, but it happens here because of the absence of a clean break. And I think what we need to look at is we now need to look at the time and the circumstances in which a receiving spouse can return to the court to seek further provision. We never looked at that at the time of the divorce referendum. Another issue we never looked at...
A lot of that had to do with the fact that we didn't consider wealth in this country. We felt that wealth belonged to a tiny minority of people, and that people with large salaries are huge amounts of real estate, as we now see here in Ireland, as you said, 33,000 millionaires. We didn't anticipate when they were looking at the bill that eventually led to the Divorce Act. We didn't anticipate that we would have people who would have a lot.
Yeah, and you're right, because we now have considerable economic growth.
You're stuck in traffic. You don't like your job. Your boss is evil. Your car is falling to pieces. It cost more to fill it with petrol than it did to buy. People always think you're 10 years older than you are, because you are. Nothing you own is actually paid for. Your house payment is 3 months overdue, and so is your girlfriend. Nothing is as important as The Will Leahy Show, Monday to Friday, 5 to 7 p.m. on 2FM. Everything else can wait.
2FM. We're talking about divorce law and the practice and the kind of law that exists in this country compared to the rest of the world. And you'll see that we substantially differ to the UK, though we are so close in many other respects. The author of Divorce Law and Practice, Geoffrey Shannon's in studio. I point out that the proceeds from the sale of this book are going to charity, because Geoffrey's so wealthy. Doesn't need the money. So. Now, we were talking about nullity at one point just before the interview started, and I recall as a young lawyer, nullity was the only way for a... Well, not for the marriage never existed in the first place. That's what you were looking to describe. But it was our equivalent of divorce in a way. And of course, Declan Costello, at the Attorney General at one stage, I think would have tried to maybe have it continue to be that way. That was the job he was sort of given, to make it more sophisticated. As we know, that turned out not to be the case. But for a long time, it was the only legal framework whereby a couple could separate. Divorce says the marriage is over. Nullity says it was never there in the first place. Now, what I'm shocked by is your declaration that nullity is by no means out of date. It may be out of date, but it's by no means out of fashion.
Yeah, it's very popular, of course, nullity, because if we look at divorce, what's the difference between divorce and nullity? A divorce dissolves a valid and existing marriage between two parties. When a marriage is declared null and void, a court is declaring that the couple were never legally married to each other and are free to remarry. So what are the consequences? Well, the consequences in the context of a divorce is that there are ongoing financial and other obligations. There are no financial consequences in the context of nullity.
Because it was never there in the first place.
It was never there in the first place. And what we've seen in terms of since divorce was introduced is the nullity figures have been rather erratic. So they've gone up in certain years rather than gone down. And there are three reasons for that. First would be religious reasons. Like if you don't want to obtain a divorce, and let's not pretend that divorce is universally accepted. And that would be the first reason. The second one is that, remember, you've got to be living separate and apart for 4 out of the previous 5 years. Now, if you're not living separate and apart for 4 out of the previous 5 years, and you've got this ideal partner waiting in the background, and you want to remarry, well, of course, nullity then is extremely attractive. But the most important one is that it avoids the continuing financial and other obligations that emanate from a divorce. And we need to address that because of the fact that nullity should not be a remedy available to parties who want to avoid their financial obligations. And there were, I was mentioning to Gerry just during the break there that there was one case where the marriage lasted for 23 years and the court granted a nullity on the grounds that the petitioner did not realise that a psychiatric illness could found a ground for relief. In another case, 13 years. So we've got to bring some order because if we look at the grounds for nullity, there are probably 5 grounds for nullity. The first one will be the lack of capacity. In other words, two people need to be 18 years of age before they marry. And if they're not, you don't have the capacity. That would be an example. The second would be the failure to comply with formalities. Your 3 months' notice. If you fail to give your 3 months' notice, well, then your marriage is void. It never existed. And the third would be the lack of valid consent. So you must give full, free and informed consent.
Or misleading somebody about a fundamental dimension. For instance, if you're homosexual, if you've got no penis, there's a couple of basic things that have to be there for the marriage to...
Yeah, and we've no difficulty with those, but we have a difficulty. I would have thought we have a difficulty with the 2 other grounds. And the first was impotence, that a party is unable at the time of the marriage to consummate the marriage due to physical or psychological impotence. And that has nothing to do with the capacity to procreate. It's a relic of medieval times where the first act of sexual intercourse marked the wife as a property of her husband. I think we need to get rid of that. But the one that causes the greatest difficulty is the ground, this inability to enter and sustain a normal marital relationship. That's much more closer to a divorce or judicial separation case. And just to give an example as to what you need to prove there, in one case, emotional immaturity was used as a ground.
Successfully.
Successfully.
Yes. So
if I wanted to plead emotional immaturity to get out of a contract, of course it would be very attractive. A lot of us would be delighted if we could plead emotional immaturity to get out of obligations we don't want to follow through on.
We might very successfully plead it, many of us.
Exactly, correct, yeah. So it would leave a lot of marriages.
But is it a good legal basis for making a decision? No,
would be my view. And I think we need to reevaluate that now as a matter of urgency.
Yeah, my suspicion has always been that really what happened when most people, I'm not saying everybody, when most couples, and it's usually a double-headed job, come looking for nullity, what you were really doing is you were training them how to answer the questions so that the court would be satisfied that the grounds existed to declare the marriage null and void. You were really training them up to that. In other words, it was not malicious or vexatious, but it wasn't entirely upfront. So therefore, we need to modify that.
We need to, because the bottom line is that marriage is a very serious commitment. As I said in the book, it's a gold standard. And if we're going to treat marriage as the gold standard, well, then we've got to make sure that if you want to avoid saying that you are married, that you've got to satisfy a very high threshold.
We're already seeing some debate in court over the definition of certain aspects of the Irish divorce law. For instance, the having to live separately 4 of the 5 years from your spouse before you're entitled to be given a divorce. That now seems that time could take place conceivably in the same building.
Yeah, exactly.
You don't have to be in another house or another home.
Yeah, there's a High Court decision on that saying that living separate and apart involves 2 aspects. There's the physical living separate and apart, and then there's the psychological living separate and apart. So the 2 people inhabit the same house but not the same household. So take, for example, that case that went before the High Court. The husband actually had a separate existence in his own room. He had his own television in his room. He had his own phone in his room. He went on holidays separately from his wife. These are the type of factors that you will take into account. Now, what could be fatal is if you enjoy meals together, that could be fatal to establishing that you were living separate and apart. So there are 2 aspects, the physical and the intellectual aspect.
Now, at long last, Heather Mills. And of course, the reason we're also interested in Heather Mills, if anybody has any interest in divorce, is that it's another case in a number of cases showing that even though you've only been there for a short while within the relationship, even though you're not, ostensibly, it doesn't really look like you've contributed all that much to it, she has, of course, delivered a child to the relationship, she may in fact be entitled to an astronomical amount of money.
Absolutely. And last year there was a case which I think Heather Mills' lawyers must have been looking on gleefully at. It was a case involving the Chelsea football manager, Roman
Abramovich.
Exactly. Yeah. So he had actually separated from his wife. And people were speculating as to what the payout was going to be. And Abramovich, I suppose, sought to argue the same type of argument that we heard in the Cowan case.
I am an oligarch. Nobody made me except me.
Yeah, so in true Russian style.
And he was very upfront about that.
Very upfront. And if we look at, she ended up getting 155 million as a result of that settlement. Now that certainly must have been music to the ears of Heather Mills' lawyers. And the cases we discussed earlier had a huge impact, I would have thought, on settlement negotiations. Particularly the McFarlane case, the fact that she was getting £250,000 sterling a year.
Her comment? I may have been described as only a bikini on his yacht, but remember, I was the bikini.
Exactly, yeah, and that's what it's about. What it's about is it doesn't now really matter as to the duration of the marriage. You may still be entitled to a significant payout. Remember, if we look at the rule, appears to be that even in a short marriage, that you may be entitled to 50% of the income generated during that marriage.
Now, if Paul McCartney's lawyers had taken your advice, I presume it would have been to come over here and file for the proceedings in a Dublin or a Cork or a Limerick court. What would the difference be in the outcome, do you believe? Not that we can't presume the outcome, but we've a fairly good idea that she's going to do very well. Yeah, she's going to get 50% of it.
Yeah, in my opinion, she wouldn't do nearly as well in this jurisdiction because remember, the starting point here would be a third of the assets, and the court looks at a host of factors. So it's not equality. It's more a third of the assets. And one of the factors the court will take into account, a significant factor, will be the duration of the marriage. In her favour will be the fact that there is a child of the relationship. And that is a significant factor.
But you're not going to get 15 grand a day for the child.
Exactly. So certainly she's going to do much better.
Now, what I stand up for, my lord, that's all very well for the man on the Howth tram. But my client, Ms. Mills here, she has to bring her child to school in a Sikorsky helicopter, and they go away for the weekend in a private jet, and they eat gold-plated Weetabix. And will the court have any interest in that argument?
Not hugely exercised, because that was the argument that was adopted in the past. Now what they're interested in is they're interested in the UK inequality. Here we're interested in proper provision. Now we haven't had in this country can Dad live in the mansion in Ireland and Mum live reasonably well in a lesser environment? Yeah, with the children. Family home is an interesting one because the fact that the family home is a source of stability for the kids. And of course the judge is going to be aware of that. So the judge is going to be very reluctant to turf the wife out of the family home. And that will inevitably not happen. Yes, exactly. So the only other option is actually to ensure that the husband has the resources to establish another residence for himself. And that's how the court might deal with that. One exception is the family farm. And the family farm is very important in the Irish context. So Dad doesn't have to live in a house that's as nice as the family home. No. Once there's a pillow and an electric light and a toilet, that's all he needs. And I suppose the point of departure is the family farm, because the family farm is a business, and the court will depart from this benchmark of fairness in Ireland to ensure the survival of an income-generating asset. So you're not going to bite the hand that feeds you. Well, the court will not sell an asset, will not sell, say, the family home if it will destroy a business or a future income of the party. So what might a court do in the context of the family farm? And that's hugely important in the Irish context. The court has about 5 options. The first thing it can do is it can provide substantial periodical payments, so substantial maintenance to the wife. It can provide a lump sum. It can partition part of the farm if the farm can easily be severed. It can sell part of the land to enable a lump sum, or it can do a mixture of both. It can transfer part of the land and sell another portion to raise funds to provide an alternative residence. Those are the options. But there was a case, farming case that came before the High Court. The High Court judge said that it would be unjust to treat the wife on any basis less than equality. But how he dealt with that was that he gave a large lump sum to satisfy the wife's needs. Now, that case was never fully heard before the Supreme Court, so we don't know how the Supreme Court would jump on that.
Now, in terms of the family home, which is a very emotive issue as well, because, it's inevitably the man leaving the home. And, for better or for worse, a lot of people are going to be discommoded by that, not least of all him, I suppose. But the kids will be affected by it. There is a misconception in this country that that's it. Then the remaining spouse, almost inevitably the wife, stays until her death in that house or until she decides to sell it. That's not true.
It's not true. There are a number of options the court has. The first one is to leave the wife in the family home until the kid reaches 18 years, or if there are multiple children, until the kids reach 18 years of age. Another option would be to sell. If it's a large family home and there isn't enough to go around, because what we've been talking about now is the big money cases. In the majority of cases, most of these cases are heard at circuit court level, and you have little more than the family home and the pension. You may have small savings. Yeah. So you don't have the money to work around.
There's no Abramovich, no Paul McCartney in most cases.
Yeah, there's no 155 million swanning around. So what the court will do is the court will generally leave the kids and the wife in the family home until they reach majority or until they've finished full-time education, and then they sell the house.
And that gives mum and dad a chance to have some pension, as it were, later on in their lives.
Yeah, and people forget about the pension, Gerry. The pension is the second most valuable asset.
Oh, yeah.
Particularly if it's a civil service type of pension. And we sometimes forget that, and that's something that needs to be looked at. And what we need to do is we need clearer principles as to how you deal with those cases rather than the big money cases.
OK, it's been a pleasure talking to you. I hope it was of some use talking to people this morning. I really believe that there's a massive degree of mythology associated in the layperson's mind about Irish divorce, and indeed how to go about getting a divorce and what it will deliver. Suffice it to say, we leave you with this thought, that it's a very serious business indeed, a very serious business to be approached in as least an emotional way as you possibly can. Fine words, not reality, but it's the advice we give this morning. Jeffrey, thank you very much indeed. Congratulations on the book.
Gerry